Hello everyone, myself Mansi Asija, and my topic is restitution of conjugal rights. Let's ask one question: what is conjugal rights according to you? Conjugal rights means right to stay together. According to Hindu Marriage Act 1955, Section 9 says if either the husband or the wife without reasonable excuses withdraws from the society of the other, the aggrieved party may approach the court for restitution, no, a restitution of conjugal rights. Right? I think you understand this point. Let's talk about matrimonial reliefs. The marriage of Hindu jurisprudence is a sacrament. Okay, the Sastric Hindu law did not know the terms of divorce, restitution of conjugal rights, judicial separation, etc. These terms have been incorporated in the Hindu Marriage Act 1955 by influence of English law. This is the introduction of matrimonial reliefs. The judicial remedies mentioned hereunder have been provided in the Marriage Act to the parties to an unhappy marriage. They are restitution of conjugal rights, that is section 9, judicial separation, section 10, divorce, section 13, nullity of marriage void marriages, section 11, voidable marriages, section 12. What is restitution of conjugal rights? Matrimonial reliefs are explains sections from section 9 to 13 in the Hindu Marriage Act 1955. Section 9 provides about the restitution of conjugal rights. Divorce is a drastic step. It puts an end to the matrimonial life to the parties of the marriage. There is no chance of reunion between the wife and husband. They are entitled to marry another person according to their choice. Restitution of conjugal rights is a hope of getting nearer both the spouses and avoids conflicts between them. It is a ray of hope only. It is a last resort to establish amicable relations between them. Sometimes the wife and husband may live separately due to conflicts. The decree of resolution of conjugal rights may bring them together and get them united, which is the object of the marital life. What is written in the Bare Act of Section 9? Section 9 Resolution of Conjugal Rights in Bare Act, it is written that when either the husband or the wife has, without reasonable excuse, withdrawn from the society of the aggrieved party, may apply by petition of the district court. Always remember, district court, it is applicable for resolution of conjugal, and the court, on being satisfied the truth of the statements made in such petition, and that there is no legal ground why the application should not be granted, may decree restitution of conjugal rights accordingly. Now the question arises that whether there has been reasonable excuse for withdrawal from the society, the burden of proving reasonable excuse shall be on the person who has withdrawn from the society. Essential ingredients: by marriage, the husband becomes entitled to the conjugal society of his wife and vice versa. The wife of husband withdraws from the society of the other due to conflicts. The aggrieved party is entitled to the restitution of conjugal rights. The aggrieved party shall apply by petition to the district court. The district court must satisfied with the contents of the petition. that the other party withdrew the society or the other without reasonable excuse, and there are legal grounds to grant a decree of restitution of conjugal rights. The withdrawal from the society of the other by any one of the spouse must be without reasonable excuse. This remedy was known to England long back, but it was abolished there with effect. From 1970, this remedy is incorporated in the Hindu Marriage Act 1955 and still now continues the social, economical, and marital relations in India cause this remedy to continue there. Okay, the burden of proof lies upon the petitioner who submits the petition for restitution of conjugal rights. If respondent has a valid and reasonable ground to live separately from the petitioner cannot succeed in a suit for restitution of conjugal rights. An agreement between husband and wife to live separately is void that is contrary to the public policy. Now, let's talk about. There are three important requirements uh, to be fulfilled in section 9. First, spouses must be staying together, must not be staying together. Second, withdrawal of a party from the other have no reasonable ground for withdrawal. Third, the aggrieved party must apply for restitution of conjugal rights. Basis on which petition for restitution of conjugal rights can be rejected. First point, if the respondent is capable of claiming any matrimonial relief. Second, if the petitioner accepts that he has committed any matrimonial misconduct. Third, if the petitioner action makes it impossible for the respondent to stay with him. Where to complain on this? In the civil jurisdiction, in the civil court in whose jurisdiction? First, the party's marriage was performed. Second, the husband and wife stayed together. And third, the husband and wife last stayed. What the aggrieved party can do? The aggrieved party can file a petition in the district court. When the court gets satisfied with the aggrieved party's contentions, and when the court finds no reason as to why the aggrieved application should not be supported, the court may decree restitution of conjugal rights in the aggrieved party's favor. What can be the next step? The decree of restitution of conjugal rights will be actioned according to the Civil Procedure Code 1908. Just remember that. The aggrieved party can approach the High Court challenging the lower court's decision. During this period, whether the wife can ask for maintenance? Yes, of course, wife can ask for maintenance. The wife can claim maintenance under Section 25 of the Hindu Marriage Act. This decree, if not obeyed, the court will attach the judgment debtor's property. Further, if this decree is not observed for a period time frame of more than a year after the decree date, then the divorce ground is created. I think conjugal rights is cleared. The is cleared, and all the doubts has been cleared. And thank you for watching this video. And please do subscribe this channel and this video. Thank you.